of system. And for this, I will actually point you to other district court authority we think is much better reasoned. This is Potter v. Havlicek out of the Southern District of Ohio. This is a court that was decided after ROP, cited ROP, and disagreed with it. And in this court, they said the ROP court misunderstood and misread the definition because they neglected the word effects. And even if we were to define the system to exclude the little bit, the 3 inches between wherever the video buffer RAM is held and the CPU, even if we're able to do that, this still affects the larger system. In this case, we're talking about instant messaging. The thing that was intercepted were the communications between people on an inherently worldwide internet-based network. And so it just doesn't make sense to read in this constrained way. The final thing I'll say about this is the Potter case also involved screen capture, like we're talking about here, unlike the ROP case, which was just keyloggers. And so there's a different dynamic about the types of messages that are stored and the types of messages that are intercepted. So for all these reasons, we urge the court to deny this motion.
Thank you, Mr. Rome. Appreciate the briefing on this and the concise argument here. It's clear to me, and it seems conceded by both parties, that the communications that were acquired here were internal, that there was not a sniffing of the wire to pick up communications as they left a device or were transiting to another device. And as a lifelong judicial official, I'm very familiar with the internal workings of computers. But I do think that the question here is really one of a fact for the jury to decide. First, whether this actually affects interstate commerce, and second of all, whether the system is broad enough, the term system is broad enough to include that portions of the laptop that were affected here, such that the Wiretap Act in this case would actually cover the acquisition of the data as it sat in video RAM. I'm going to leave that question for the jury to decide. I think the other courts have determined that that was actually a question of law for the judge to decide. I may revisit that. But at this point, I'm going to allow that to go to the jury for the jury to decide. So I will not be dismissing count 2 of the indictment. Are there any other matters, prosecution, defense, that we need to raise at this point?
No, Your Honor.
Thank you. All right. That leads us to the final phase, or the last couple phases of the trial. You've heard from all of the witnesses that both sides have to present. And I will remind you that in order to convict the defendant here, you've got to find that the prosecution has proved beyond a reasonable doubt each of the elements for each of the charges. If you do not conclude for any particular charge that an element has been satisfied by the government, then you must find the defendant not guilty on that count. Reasonable doubt is proof that leaves you firmly convinced that the defendant isn't guilty. There are a few things in this world that we know for sure and that we have absolute certainty about, and the criminal law doesn't require that level of conviction. It really requires that the government's proof exclude any reasonable doubts about the conclusions which it's drawing about the defendant's guilt. That said, the presumption here is that the defendant is not guilty unless you are convinced that there's no reasonable explanation for the evidence that has been presented that shows the culpability of the defendant. There's a couple charges here that we're going to talk about. The first one is the remaining wiretap charge. On this account, the prosecution has to prove, again, beyond a reasonable doubt, that the defendant intercepted electronic communications, and in this case we're talking about those instant messages. There are really essentially 3 elements that have to be proved here. First, that the defendant intercepted something. Second, that that something was an electronic communication, which is a defined term. An electronic communication, as you can see from the slide, is any communication where there's a transfer of signs, signals, writings, images, sounds, data, or intelligence of any nature that's transmitted by a wire, radio, electromagnetic, photoelectronic, or photo-optical system. And as you heard before, it also has to affect, the system has to affect foreign or interstate commerce. It's also important for the government to show that the interception was intentional. So it's up to you to determine if the government has satisfied each one of these three elements with their subparts beyond a reasonable doubt. On the third charge of hacking, the prosecution alleges that the defendant intruded upon this computer and obtained information. To prove this charge, and for you to find the defendant guilty here, you must find that the prosecution has shown beyond a reasonable doubt that the defendant intentionally accessed a computer and did not have authorization or exceeded whatever authorization the defendant had, and in doing so, obtained information from a protected computer. And I will note that in this case, the sides have stipulated that the computer here falls within the definition of a protected computer, and that the defendant committed this offense for the purpose of commercial advantage or private financial gain. Again, if the prosecution fails on any one of these three elements, you must find the defendant not guilty on the overall charge. At this point, now that you've been duly charged with instructions on how to reach a verdict, we turn to the closing argument phase, and the prosecution goes first. The defense, if it wishes to offer a closing, would go second, and the prosecution, if it elects, would have a rebuttal. Mr. Ohm?
Thank you, Your Honor. Ladies and gentlemen of the jury, I really do thank you for your patience. The government likes to say that we never present a closing argument, we present a summation, because we think that the facts of this case, as with every case that we try and bring, establish beyond a reasonable doubt that we have met the burden of what we are set out to do, which is to show you that the defendant here has committed a wrongful act. Now, the judge has talked to you about the intricacies of these, I'll admit it, kind of strange laws that use lots of words that have highly technical legal definitions. The really good thing, I think, for the jurors to understand is that we're talking about 2 counts here, and each count has 3 different things that we must prove. And although I'll go through and show you in this closing argument, the summation, how we've met each of those 3 things, in reality, there's really only one thing being disputed for count 2, and there's only one thing being disputed for count 3. And I think that's where we'll spend our time. Count 2 is about the screenshot that was taken of the instant messaging conversation. And the question here is this an unlawful wiretap? I think it's hard to dispute that there was an interception here and that this interception was intentional. You heard the testimony of Agent Stroker, who found copies of the screenshot that were made by someone who exploited Absolute Manage software. You heard that this software was exploited on Brutish's computer. You found that the identical software was found on the defendant's computer. You've learned that the journalist received a copy of the screenshot, and you learned that the defendant had a copy of the exact same screenshot and the exact same email message on his computer. Then you heard from the defense expert, Mr. Hobbs. And in step-by-step detail, he provided proof. He provided the trail that the defendant, Mr. Weasel, took as he made these unlawful copies. Second is the requirement that this was an intentional act, and we don't always have such an easy job of this element in federal court, but the defendant admitted it. The defendant, under questioning from his own attorney, said, "I did it. I did this act." And so as I promised you, this first count number 2, really turns on this definition of electronic communication. And what you need to determine as a jury is, did the screen capture, which the government concedes happened on one computer, involve a transfer of information in whole or in part by a system that affects interstate or foreign commerce? And I think we've plainly established that these computers that were connected to the internet satisfy this. Please turn with me to count 3. Count 3 is under the federal hacking statute, the Computer Fraud and Abuse Act. And again, I think we have the same story here. 3 elements, but only one is really in dispute. Element 1, intentionally accessing a computer. This is satisfied completely, fully, and beyond a shadow of a doubt through the confession of the defendant. Step 2, information was obtained. You've seen the PowerPoint slides that resided on Mr. Zuckerson's computer that were lifted through Mr. Brutish's computer, and a copy of which ended up with the defendant and ultimately with the journalist. Element 2, I think, abounds with evidence in this case. So this, again, brings us to the third and final element that you must look at in this case. And you're going to hear, I predict, from the defense, a very long, convoluted argument about how the government failed to prove that what this case involves is either commercial advantage or private financial gain. But what I want you to do is, when you get back to the jury room, to study the evidence, what I think is the ample evidence of both of these things. Number one, commercial advantage. The judge did not define what this means for you, and that's because the law doesn't either. You're supposed to be guided by your understanding of the ordinary English language about what these words mean. Commerce. This doesn't say anything about the corporate form. It doesn't say anything about employers and employees. It only says that your motive, at least as far as you can divine, was commercial. And I think that when you look at the evidence, when you see that defendant was the lead coder, the inspiring force, the person who was associated with the Vapor Aspera project, the Vapor Aspera project, by the way, which was a direct competitor of my TwitFace, you'll see the motive of commercial advantage. The defendant is going to make a big deal about the fact that our case is circumstantial, and I concede that. We don't have a smoking gun email that says, this is my motive, I can't wait to do it. That would be wonderful. It would have saved us a lot of time in court. Instead, what you need to do to jurors is dig into your well of human understanding. Look at what happened immediately after the compromise. Look at the email messages that we've presented before you and ask yourself whether this sounds like commercial advantage. The user base for Vapor Aspera climbed 75% in 1 month. People were abandoning my TwitFace and going to Vapor Aspera. The defendant on the stand said, there are no immediate plans to monetize this project, but there could be in the future. So take that back with your jury room and ask you if that satisfies commercial advantage. And then I think you should also look at the evidence of private financial gain. A mere 24 hours after this occurred, the defendant was offered $5,000 in an honorarium to give a speech. Since then, other similar opportunities have come in. His email accounts have begun to grow in leaps and bounds. The number of friends he has on his social network have begun to grow as well. There's a great amount of private financial gain that was obtained. It's for you to decide whether this was the motive animating the attack. One other thing I'll say about motive. You can find in your heart that the defendant had more than one motive. That the defendant sure thought that this company was a bad company and needed to be taken down, but also that there was a commercial advantage or private financial gain. And that brings me to my last point. My TwitFace isn't on trial. Sure, you've seen some testimony of some people that you may not think are the nicest people in the world. You might be glad that you don't work under the heavy hand of Maria Batali as your computer security person. You may not think that the CEO is someone you'd want to bring with you on your next family vacation. They are not on trial. This is not about the company, but the defense counsel, through their questioning, and I predict in their closing argument, will try to make this about the company. The only person who is on trial is Weasel. And look at his actions. Ask yourself, is this the kind of person who's a hero, who's a paragon of virtue, who's someone we should celebrate, or is this a person who broke the law and who should go to prison? Thank you.
Mr. Upsall?
Thank you, Your Honor. And ladies and gentlemen of the jury, Mr. Weasel is a hero. And we've seen the efforts that he has made to bring the truth about my TwitFace to the public. And he's right that about a few things. Rare that we will agree with the prosecution, but it does come down to primarily two things in counts 2 and 3. But as the jury, you need to find